Hi, my name is Scott Smith, and I'm a technical consultant for the Center for Behavioral Health and Justice at Wayne State University. One of my technical expertise is the area of law enforcement, and I have a small glimpse into what life is like for law enforcement as I've had the chance to serve as a reserve police officer for a number of years. In addition, I'm a mental health clinician with over 20 years of experience. And today we're going to talk about assisted outpatient treatment and when is it appropriate for law enforcement to consider utilizing assisted outpatient treatment. Law enforcement may consider assisted outpatient treatment orders for members of the community for different reasons. It's important to recognize that we know law enforcement has regular contact with individuals who are living with a serious mental illness. This occurs because of high rates of housing instability common to individuals living with a serious mental illness, in turn resulting in increased 911 calls, whether it be due to petty offenses like loitering, trespassing, yelling at customers in front of a store, or from more serious domestic disturbances. That is, somebody's couch surfing. Somebody takes in someone that has a serious mental illness, but that illness has symptoms that lead to a lot of conflict, and you end up getting involved. We know that across the board, individuals living with a serious mental illness are very often exposed or subjected to violence, and they also have high rates of substance use, both of which lead to very frequent contacts with law enforcement. And we know that many individuals who are living with a serious mental illness are actually unknown to community mental health. Law enforcement could actually serve as a very important link between the individual and the treating authority. The reason why many individuals with serious mental illness are unknown to the community mental health is because they're not eligible traditionally for services. Because individuals who are designated as having a serious mental illness also qualify for disability benefits, which includes Medicare, they technically are not the responsibility of community mental health unless there's an order for assisted outpatient treatment. As a result, many of the individuals with the most serious mental illness have very little, if any, contact with treatment providers. The eligibility for somebody to be considered for assisted outpatient treatment consists first of them being an adult who has either a serious mental illness or a developmental disability. It's important to consider here that most individuals with a developmental disability are probably better suited to guardianship and assisted outpatient treatment, but this is really where your partnership with community mental health can help determine the best course of intervention. We'll discuss the merits of assisted outpatient treatment relative to guardianship in just a moment. So for individuals who do have this eligibility of being an adult with serious mental illness or developmental disability, specifically, we're looking for individuals who do not understand that they need treatment at all because of their impaired judgment resulting from their mental illness. This is what's often referred to as anosognosia. There are individuals who are unlikely to voluntarily participate in or adhere to treatment necessary to keep them from harm. And their past behavior is also a big predictor of this, but certain symptoms, such as paranoia of treatment providers, also contributes to this behavior. They must be a person living with a mental illness, not somebody who exclusively has a substance use disorder or a form of dementia like Alzheimer's. Anything that's not related to the direct manifestation of the mental illness is not applicable for consideration for an assisted outpatient treatment order. And most importantly, eligibility is directed at those individuals who, without treatment, are likely to deteriorate, resulting in harm to themselves or others. And when we know of a past history where that's happened, that helps really ensure that we're choosing the right person for an assisted outpatient treatment order. And I want to highlight here that without treatment, likely to deteriorate means intentionally or unintentionally resulting in harm. whether it's they become so despondent they want to try to end their own life, or they become so paranoid that they take risks to avoid harm that doesn't exist. In either situation, if they don't receive treatment and are likely to experience harm, AOT might be a great option. Now, unfortunately, assisted outpatient treatment doesn't work for anybody. It's not a cure-all, but we do know it tends to work well overall, especially for individuals who are younger rather than older. The biggest reason appears to be that when somebody has lived with a serious mental illness for a long time, they often adopt practices of behavior that aren't actually linked to their mental illness directly. That is, they might rely on emergency rooms and inpatient hospitalization for treatment as opposed to outpatient treatment to avoid those things. These bad behaviors, these bad habits, assisted outpatient treatment isn't as effective at addressing that. However, somebody who is younger or earlier in the stage of the onset of their illness, actually they seem to respond very well to assisted outpatient treatment. In fact, there's a lot of emerging evidence that assisted outpatient treatment early in the course of somebody who's living with schizophrenia might be the difference between a relatively autonomous life and one of constant institutional dependence. In terms of diagnosed mental health problems, individuals who are diagnosed with a psychotic disorder, such as schizophrenia, schizoaffective disorder, or bipolar disorder, major depressive disorder, where they often have what we call psychotic features. That is, in their manic episode, they're experiencing grandiosity, auditory hallucinations. In their depression, they're experiencing anhedonia, that is, a complete loss of interest or pleasure in anything. And not just the normal, like, loss of interest, but a completely all-encompassing loss in anything, resulting in meaning. Individuals with these symptoms respond very well to certain medications, and as a result, assisted outpatient treatment tends to work better for them. There are individuals who primarily don't adhere to treatment because they don't recognize that they're sick. That's that anosognosia again. And they're individuals who can actually tolerate taking medications. So they don't have allergies that make medications contraindicated, that would be harmful to them. The good news is the younger somebody is, the less likely it is that they're going to have these types of allergies. And then finally, they've demonstrated at some point in late adolescence, early adulthood, that they have the life skills necessary to sustain housing and employment. That is, we believe that they're, with treatment, likely to be able to be relatively autonomous. So when is guardianship a better choice than AOT? Well, I'm including this information for your information because you have so much responsibility, for better and for worse, with this population. And I believe it can be helpful for you to recognize where one might be more appropriate. It's also helpful that as we're having a bigger conversation now around the role of guardianships, conservatorships, and how very often they're applied quite broadly, it's important to consider that in some cases, assisted outpatient treatment should be a first step before guardianship is considered. So when is guardianship the better choice? Well, if you think about who are the best candidates for assisted outpatient treatment, you can kind of think about the opposite of that. So for individuals who are unlikely, even with treatment, to be able to make sound, independent decisions, to function autonomously, it's unlikely that with treatment, they're going to magically gain these skills. Also in this category, many individuals with developmental disabilities probably would be better served by guardianship because the nature of their illness impairs so many aspects of function that they are always going to need much more help to be able to get by. And then individuals who have medication allergies, medical conditions, something that would prevent them from being able to tolerate other forms of mental health treatment, for them, guardianship is probably going to be the best option. So when we consider all of this, as members of law enforcement, you do have a unique perspective on who might be a good candidate and often see them long before community mental health even knows they exist. So how do you initiate an order for assisted outpatient treatment? This is the general process that's available to anybody that's an adult over the age of 18 here in Michigan to complete. One thing to consider is that if you're working with families who are drawing your attention to somebody who needs treatment, you might be better served by helping connect them to community mental health to complete this process, or guiding them to complete this process for themselves. Ideally, as law enforcement, you wouldn't have to be the primary initiator of this process very often, but depending on where you live, the resources available to you, it might be necessary. So I want to walk you through the process. And if nothing else, it'll teach you the process so you can teach it to family members who might benefit. So in general, it starts with an adult filing a petition. And it's important to note that the petition form used for assisted outpatient treatment is the same one that you've been using for involuntary hospitalization. The petition is now one form, does it all. And you're going to request either assisted outpatient treatment only or a combination of assisted outpatient treatment and hospitalization. And as I walk you through this form step by step, I'll explain why you would consider one option over the other. From there, the probate court reviews the petition and schedules a hearing within 28 days. In an emergency situation where hospitalization is not requested, but there's concern that there be an earlier intervention, an order for transport examination can be issued so that you, as a member of law enforcement, can take that person into protective custody and take them to a place where they can be evaluated. This waives the necessity of you finding your own probable cause to do a transport, to initiate a protective custody situation. And it's important to recognize that when you receive a valid transport order, it carries the same force and effect of any other judge's order. So consider it equivalent to a warrant. A psychiatrist is going to evaluate the patient once they have access to them and make the determination of whether AOT is appropriate or not. They will then report, testify to the court, file the treatment plan with the court, and if the court feels there's compelling evidence, an initial assisted outpatient treatment order is issued. It can be issued for up to 180 days at first and be renewed from there. It can also be discontinued far earlier, depending on how things are progressing. Here's how to complete a petition for assisted outpatient treatment. So this form should look very familiar to you. This is the PCM 201 form. Please note that you need to pay attention to the changes that SCAO puts out to these forms, because a form that is outdated may not be accepted by a hospital or evaluation center. The petition is what you've used for involuntary hospitalization for a number of years. And we're going to pick up at box 3 or line 3, because this is really where we're going to start to see a difference from what you do for involuntary hospitalization, what you're going to do for assisted outpatient treatment. So box C is the box that you should only be checking if you are recommending assisted outpatient treatment. Now, depending on the type of training you've had at completing these petitions, you might be inclined to check these all the time. But box C uses language that specifically references the law around who is eligible for assisted outpatient treatment. So if what you're doing is trying to get assisted outpatient treatment, whether that's with or without hospitalization, make sure box C is selected. Now, if you can check box A or box B, then the reality is that person does need immediate hospitalization. So if box A or box B can be checked and box C can be checked, you're going to be requesting that they have a combined order for inpatient hospitalization and assisted outpatient treatment. Now, moving on to the second page, and I will get into some specifics on each line in just a moment. If you're requesting that the individual be immediately evaluated, but not be hospitalized, then you're going to put a check next to line 7 and also put a check mark in the no clinical certificate is attached. And the reason you're going to select that box is because until there's an evaluation by a physician or a licensed psychologist, there's no way to have that certificate. So you won't have it available to you. For box number 8 on line 8, if you want immediate evaluation without hospitalization, check box 8 and 8B. Now, depending on where you reside, the place that you select for box B should be the best evaluation location for your specific area. I use here Wayne County, an example of one of their crisis providers of COPE. But this can be your local ER, if that's where it's provided, or if you have a drop-in center available to you. On box 9C, you want to make sure that you're only checking C if you do not want hospitalization. If you want hospitalization and assisted outpatient treatment, select box B. You do not need and should not select more than one box under line 9. Now, the new form that you should be using to protect patient confidentiality is this MC97A form. And it basically is going to contain the necessary information that will be obscured from the petition, that is the date of birth and the social security number. Because petitions are public documents, this is a long overdue improvement to everybody's privacy, but do make sure that you are completing this. You are the plaintiff or petitioner. The defendant respondent is the person you're petitioning, and you're going to put their name under the defendant respondent name in the matter of line and under the name in the first line, line 10, where you're going to also add their date of birth, and in the other column, place their social security number if you know it. Going step by step through the petition process, when we get to the in the matter of, this is the individual that you're petitioning. If you know their full legal name, can confirm that. That's helpful to place here. If they're unknown, then John Doe, Jane Doe, completely acceptable here. Right? You don't need to worry about the court or the court will provide that. For place of birth, this is something that is a newer adaptation for completing petitions for any purpose. You just need to put the state or the country if they're born outside of the US. This is basically to help the court keep people separate and can be helpful if they're entering information into the National Criminal Incident Check. Under race, use the traditional census categories. Those are the ones that seem to be preferred. I've listed those here on the screen. And for sex, it must be their legal sex. If they identify as a different gender, you can note that later on in the form, but use their legal sex here under current Michigan law. Line 1, you're the petitioner, so you'll put your name there and your relationship. So if you're completing it, you're going to put, deputy, peace officer, etc. For family members, they can put whatever their family relationship is. Line 2, they were born, you provided that on MC 97. Where do they have permanent residence? This is their legal residence, and this becomes significant more so when it's about connecting somebody to treatment, because treatment is determined by county of residence. So if they're homeless, put the county that you're in, right? It goes under the where found policy. And also if they're homeless, their street address, you can simply write homeless, and that's generally regarded as sufficient and can be presently found at wherever you are when you're going to be submitting this. So if you're dropping them off at the hospital, that's what you can place. If they're in their home and you're going to be requesting a transport order, use that address. Number 3 is where we get into the legal criteria for the petition to be valid. Box A requires that we stipulate that as a result of their mental illness, the individual can reasonably be expected within the near future to intentionally or unintentionally, and this is key, they don't have to state any plans. They don't have to state, I want to kill myself. I want to kill my neighbor. If you reasonably expect it because of how they normally act when they're not adhering to medication, because of what types of symptoms they're having. Because this can be intentionally or unintentionally, anybody who's experiencing psychotic symptoms, for instance, hearing voices, seeing things that aren't there, well, we can't predict their behavior. So as a result, if they're experiencing those symptoms, it's usually safe to check box A. Remember, the individual's behavior, the statements they make, have to occur when they're clinically sober. Obviously, you have the benefit to be able to breathalyze them. Their family may not. This can be one of those points of challenge. If you're requesting hospitalization, this is very important. If you're requesting assisted outpatient treatment only or a combined order, this doesn't really matter, because even if they are intoxicated when they're making the statements, they might not meet the criteria for inpatient hospitalization, but they do meet the criteria for assisted outpatient treatment. This is a really helpful piece of information. Unfortunately, the mental health community has not done a good job of getting this out there. So many people, every time they're drinking, they're suicidal. You probably can think of 2 or 3 people that you've transported intoxicated to the hospital multiple times. Unfortunately, we know many of these individuals will at some point act on those feelings while they're intoxicated. And under traditional inpatient hospitalization rules, there's very little we can do. Assisted outpatient treatment is different though. It does not require us wait till somebody is in danger. We can act preemptively to avoid a problem. I list here some other examples of when you can check this box. Hopefully this will be helpful information, not just for completing assisted outpatient treatment orders, but to guide you in the practice of completing these forms for any individual that you're responding to during a crisis. Box B, you can check this box for someone who, as a result of mental illness, is not eating or bathing or keeping their house sanitary. They're not taking a medication for a health problem. Maybe they have diabetes and they're not using insulin like they're supposed to. Well, if they don't do that, their condition can worsen and they can die. While we can't go around and make everybody do the right thing, the reason why we're stipulating that this is the result of a mental illness is that we believe if they were not experiencing the symptoms of their mental illness, they would be doing these things. They would be taking care of themselves. They would be taking medications they're supposed to. That's key. We're talking about somebody who normally takes care of themselves, but when they're not adhering to treatment or when their treatment isn't working quite right, their symptoms lead them to behave in this way. When that happens, we can check box B. And finally, box C. This is what we're going to check again for assisted outpatient treatment requests, regardless of if we want hospitalization or just outpatient. And this is the criteria that allows us to basically intervene in somebody's case who is not compliant or adhering, that is, to their current treatment, and allows them to be either involuntarily hospitalized or evaluated for assisted outpatient treatment, depending on the current presentation of their symptoms. As a reminder, they do not have to be currently eligible for hospitalization. That is, they don't have to meet criteria A or B. If, however, they have a history of meeting those criteria, it does make AOT a much more clear intervention. Who's an example of somebody that would meet the criteria of number C? Somebody who's experiencing psychosis, and these symptoms make them not want to participate in treatment because they believe that the medication is poison or somebody's going to hurt them. Somebody who's in a manic state and doesn't want to take the medication because they like how they feel. They don't want to feel different. Someone who has a pattern of not following through with their treatment and consistently winds up being hospitalized, arrested, or incarcerated. Those are really the individuals for whom box C was really designed. Under line 4, this is essentially the biggest part of the affidavit aspect of the petition process. There's an interesting kind of loophole in the law where the way the law actually reads, you don't have to have firsthand knowledge. However, upon judicial review, the rules of evidence stipulate that you have to have firsthand knowledge. So I always tell people, if you didn't observe it, don't expect it to survive judicial review. One pro tip, let's say you're called out to respond to a case because somebody posted something on social media or made a statement via the phone or sent a text message. In the same way that if you were interrogating a subject who you suspect committed a crime, instead of asking simply, did you do this? Did you send this message? Did you post this to Twitter? Try asking, why did you send the text message? Why did you tell your mother that you wanted to die? Most people will actually default to justifying or explaining their behavior as a way to minimize it, as opposed to outright lie about it. So that can really help you, because by explaining why they sent that message, they're also confirming it to you, which gives you the firsthand knowledge, the personal observation. Use box B to supplement what you've heard, what you've seen. So you can refer to the initial text that got you involved, or additional information that maybe the family reported to you. Also remember that if you're putting information from a witness in line B, that you need to include the witness's name, address, and phone number, as they will likely be called upon to testify about their allegations. And since assisted outpatient treatment orders are always issued by a judge during a hearing, the likelihood that they will have to testify is much higher than in situations where somebody is merely being considered for inpatient hospitalization alone. Under line 5, the individuals who have interest in the proceedings include family members, spouse, guardian. If you have the information, it can be very helpful for the court down the road. If not, that should be a part of the evaluation anyway. A reminder that if they do have a guardian, if you gain information about that, really helpful to put in here. It does introduce some considerations that may make assisted outpatient treatment order unnecessary, but the best way to handle that is just include whatever information you do have. Under line number 6, if you know their veteran status, go ahead and contribute that. If you don't know, it's okay to leave that blank. Line 7, if you were presented from a family a order for transport and examination that also came with a clinical certificate, designated form PCM 208, then you can actually check one of the top 2 boxes depending on when the evaluation took place. If that hasn't happened, you don't have any of those documentations, then you're just going to check that bottom box because you're simply requesting assisted outpatient treatment, and you don't have the other forms. Under line number 8, if the person hasn't been evaluated and as a result doesn't have a clinical certificate, or if you're unaware of one, haven't been provided one, you only need to check box 8 if you want the person to be hospitalized along with evaluation for AOT. Now, the line asks you for an explanation for why the examination cannot be secured. And this can be simply, they've been in jail, they are out of state, but we know they're returning soon. The individual refuses to voluntarily go in to be evaluated, right? And you are going to be requesting that the individual be either examined at a specific location and use your locality's preferred site. Nearest ER is also acceptable there if that's the best practice in your county. Ideally, you'll develop an improved relationship with your community mental health providers and be able to identify the best place to take somebody to improve the efficiency of this process overall. So you're requesting checkbox A, they be examined at a specific place. And if the family's filling this out especially, box B, encourage them to check that you request a police officer take the individual into protective custody and transport them to use the place in box A. On line 9, I request the court to determine the individual to be a person requiring treatment and order. Traditionally, if you were just seeking inpatient hospitalization, that's where you just check box A. If you think they need hospitalization, that is, if on line 3, you could check boxes A and or B, and you can select line C. Then you're wanting hospitalization and assisted outpatient treatment. So anytime you want assisted outpatient treatment, you're going to want to check either line or box B or box C, right? Hospitalization only will not initiate assisted outpatient treatment. Line 10, request that the individual be hospitalized pending a hearing. If you check boxes A and or B under number 3, then you should always check this box, whether you're requesting hospitalization and AOT. You want that person to not be in the community. You want them to be kept safe from themselves, the community kept safe from them. You want that person to be hospitalized pending a hearing. Be sure that you're always signing and providing the appropriate information. Because assisted outpatient treatment orders do require a hearing, many petitions for hospitalization only never make it to the court, and as a result, you may not have had to testify very often. It'll be different for an assisted outpatient treatment order. It's more likely that the person filing a petition will actually have to testify in court. So be sure to include contact information. I highly recommend using your agency's contact information and your work phone number. Remember, this will be publicly available and the individual has a right to this information. You do not want to necessarily give out your home address and telephone number. Now, hopefully what you've been able to see from this video is that the process you've been using for a long time to get inpatient treatment for an individual in a psychiatric emergency is very similar to what you're going to do to request assisted outpatient treatment. Thank you for taking the time to view this video. This training is presented as part of the Michigan Assisted Outpatient Treatment Toolkit. To learn more, visit behaviorhealthjustice.wayne.edu/AOT.